defense in this case. Mr. Chairman, initially it started when Lois Lerner disclosed this information in a fashion most calculated to be ignored, with a planted question at some boring conference. And then the second iteration of this defense was blaming two rogue agents in the Ohio field ops. And Mr. Chairman, make no mistake, Jay Carney advanced and furthered that narrative, and he did so intentionally. You know, Mr. Carney's willingness to say, I don't know, is exceeded perhaps only by his willingness to acknowledge that he appreciates the question. But he didn't say, I don't know. He advanced the narrative that two rogue agents were responsible for this insidious discriminatory practice. And then we had colleagues that said this matter was closed. Months ago, Mr. Chairman, the matter was closed. And then the new iteration of the defense is, well, at least the White House isn't directly involved, as if that's the new standard for propriety in this town, that at least the White House directly didn't know about it. So that's our defense. And then the defense, Mr. Chairman, morphed into this, the most novel of all defenses, that the IRS is too poorly managed to be capable of concocting a scheme this sophisticated. That was the defense, that my client's too dumb to have committed this crime. And then, Mr. Chairman, we moved to the most recent defense, which is that, no, we didn't just improperly target conservative groups, we improperly targeted all groups. So while we may be guilty of improper conduct, we're not guilty of discrimination, because we did it against people at both ends of the political spectrum. So that's our defense. And now to see the Inspector General attacked. You know, Mr. Chairman, there was an axiom in court: if you had the facts, pound the facts. If you had the law, pound the law. If you didn't have either one, pound the judge. And what's been said about Mr. George is reprehensible, and I can't wait till he has an opportunity to defend himself. But let me tell you what else is reprehensible, Mr. Chairman. Lois Lerner sat where those two witnesses sit today, several weeks ago. And these two witnesses put on a uniform and fought and defended this country and the Constitution, so she could hide behind the Constitution and invoke her Fifth Amendment right, but only after she blamed them. She blamed two rogue agents in Ohio, and then didn't have the courage that these witnesses. I ought to just be thankful anytime IRS agents don't invoke the Fifth Amendment. I ought to be glad that anyone's willing to come before a committee of Congress and testify. But to have these two people's reputation, or whoever she was talking about, besmirched by someone who doesn't even have the courage to come do what they're doing? Mr. Hall, I appreciate your modesty. It's not something we see very often in this town. But you have been in service to the IRS for exactly as long as I've been alive. 48 years. So whether you want to be called an expert or not, you are one, by virtue of your training and your expertise and your education, and so are you, Ms. Hoffaker. You're both experts. And if we were in a court of law, the defense would stipulate that you're experts. They wouldn't even challenge it. So I've heard about the complexities, and I've heard about the novel issues, but Mr. Hull, there's nothing novel about political activity. It's been going around since before the country was founded. So that part of the analysis, what was novel about that? What's novel about determining political activity?
Each case is looked at. It depends on the facts and circumstances of each particular case.
And you've done it 100 times. Times 100 times, right?
I'm not aware of how many political cases I may have worked.
Is it because you can't count that high? I mean, it's a lot, right?
I can't remember that far back, sir.
Well, I can't either. I can't either. But there's nothing new about political activity. And our numeric code we've had since Lord knows when. I think it's Arabic, but ascertaining 50% is not a new phenomenon. So, Mr. Chairman, I'm out of time. I'm just vexed by the complexity that our colleagues on the other side of the aisle talk about. It's political activity. 50.1% will disqualify you. And the tax code's been around forever. So what's new about this? Why did we have to have test cases? Why did we have to have Washington involved on what strikes me as a pretty simple analysis? But I'm out of time, and I yield back to the chairman.
Thank the gentleman. Chair now recognizes